Okay, good afternoon. So for today's topic, we're going to discuss about requirements for employee termination under the procedural due process. So last meeting, we already discussed the substantive due process, no? Wherein there are two types of substantive causes, which are the just and valid causes and, of course, the authorized causes. Okay, so again, when you terminate an employee, compliance of substantive due process and procedural due process must follow. So the two must be followed, no? Not just one. So both of the processes must be complied with. Okay? So procedural process requires that employee can only be dismissed after he has been given an opportunity to be heard. So in other words, the procedural process is the compliance of the employee's right on due process, no, or the right to be heard. Okay, so it is the guarantee of due process applies to all workers, including managerial employees. Where the employee denies the charges against him, a hearing is necessary to thresh out all doubts. Okay, so the failure of the employer to give the employee the benefits of a hearing and an investigation before his termination constitute an infringement of his constitutional right to due process of law. Okay, so a hearing must be conducted uh, to further investigate, no, or at least hear the side of the employee. However, if the employee, in his explanation uh, letter, he already admitted the offense or the violation, then hearing may not be necessary, no, since there's already an admission of fault. Okay. So based on the basis for the procedural process is Article 292 uh, B of the Labor Code. So it provides that the employer shall furnish the worker whose employment is sought to be terminated a written notice containing a statement of the causes for termination and shall afford the latter ample opportunity to be heard and defend himself with the assistance of his representative if he so desires. So again, the requirements of due process is there should be a written notice, that's number one, which contains the statement of the causes for termination. So whether the employee is terminated due to misconduct, grave misconduct, or dishonesty, or whatever, based on the company rules being violated, it should be stated there on the written notice. And the employee must be given ample time or ample opportunity based on jurisprudence. Ample opportunity is the standard there is 5 days. Okay, so the employee must be given 5 working days to explain. So if you do that, you already comply the ample opportunity provision or statement, no? However, again, it would depend, no? Although the standards or the jurisprudence provide that 5 days is already reasonable, but again, it would depend on the employee situation, no? Like for example, if the employee who's under investigation is on coma because he suffered a vehicular accident after committing such offense, then if, of course, comatose, you cannot say when the patient will be I mean uh, will be conscious, no? So again, of course, 5 days there is not reasonable. So you need to wait when will the patient or the employee who's under investigation will be awake, no? Okay. So again, it would depend on the situation, but general rule, 5 days is reasonable, 5 working days. Okay. So, and of course, he may bring with him his legal counsel, no, or assistants or his representatives if the employee desires. So that's due process. So the requirements, a written notice must be served on the employee specifying the grounds for termination and giving said employee reasonable opportunity, 5 days, within which to explain his 5 working days to explain his side. And then a hearing sorry, a hearing or conference during which the employee concerned, with the assistance of counsel if the employee so desire, is given opportunity to respond to the charge, present his evidence, or rebut the evidence presented against him. So that is hearing is needed, no, or hearing is or conference. So during the hearing or conference, it will be discussed further. Of course, the employee will be given more opportunity to respond on the charges, and of course, he can present more evidence on his favor, and of course, to rebut the evidences presented against him. Okay. And of course, the third one is a written notice of termination served on the employee indicating that upon due consideration of all the circumstances, grounds have been established to justify his termination. So again, there are two notices that you need to comply in order to uh, comply the due process, procedural due process. Now, first is a written notice, is specifying the grounds of termination, and of course the reasonable time to period to explain, give the ample opportunity for the employee to explain. And if there's no admission, then a hearing must be conducted or conference in order to further uh, hear the side of the employee and present evidence in his favor and rebut those evidences against him. And the second notice after the hearing and all those investigation, then a written notice of termination must be served to the employee, stating your grounds or circumstances why you came up the decision to terminate the employee. So, three notice requirement. Uh, this is again, no, that so it's why the first and second notice, or it's commonly called pre-notice, no, because of that one. So the two be must go simultaneously, no. I mean, it should be followed uh, or must be complied with, no. So notice which apprises the employee of the particular acts or omission for which his dismissal is sought. So again, the violation being committed must be written in the notice, the first notice, which is the notice to explain, and of course the subsequent notice, which informs the employee of the employer's decision to dismiss him. So in other words, the second notice is the notice of termination, or the decision, notice of decision to terminate. Okay, so this procedure is mandatory. So in the absence of which, any judgment reached by management is void and inexistent. So non-compliance of this twin notice requirement will result to void decision. Now, again, another important of the due process is the administrative hearing, or conference. So how are you going to hold the administrative hearing? So this will be the steps, no? First is prior to the meeting, you need to prepare the meeting venue, and it should be enclosed and secured without distraction. I'm sorry for the word. It should be without distraction, and you should have a recorder, and you have assigned a person to take the minutes. So in other words, you need to document the hearing by taking down the minutes, no? And you need to let everybody who are in attendance during the hearing must sign an attendance must sign the attendance, no, with their signature as proof or part of the documentation. So, and you must have all the documents or evidences ready. So if you have, for example, audio or video evidence, it should be reviewed first, no? It should be must be prepared, and it should be functional the time, especially if you are going to present that as evidence. And then you also need to prepare an agenda, or at least who will be asked First, usually this will be the order, no? So the employee or person who wrote the incident report, so the witnesses, the complainant, if any, the superior of the employee being investigated, the employees being investigated. So if there is more than one employee, meet them one at a time. Okay. So that are the things that you need to consider before you start the administrative hearing or meeting, no? Okay. Then please take note for the those reports, incident reports, it should be written down, no, and it should be signed by those who reported the incident. So in other words, you must check all or everything, no, every documents that you are going to receive as part of the evidences. Okay. And during the meeting, there should be a brief. You should brief first the committee and advise them of their role during the administrative hearing. Now, again, it would depend, no? If you have a certain specific committee members, which is what you call the grievance committee. So, so if you have those, then you need to brief them first. Okay, but there are other companies that it would depend, no, on who are invited, who are part of the hearing, will be invited to join the committee or the meeting. So again, it depends on your company policy. So then you need to start the meeting. So first, you lay down the rules. So what are the things that they need to follow? No, who will talk first? What who that example? If you need to listen, if someone is talking, no, so do not interrupt or whatever. So lay down the rules. So advise the attendees that you are recording the meeting. Thus, each one has to identify themselves, to associate the voice to a person, and concur to the audio recording. Okay. So as part of taking the minutes, you need to record, no, the meeting. But again, it's very important to ask for their consent, for for everyone's consent that you are recording the meeting, no. And of course, for purposes of identification on their voices, no, to a particular person. And then one question at a time or one person talking at a time. So, and as chair of the committee, normally the employee relations specialist, if you have, or the HR head. So it would depend, no, whoever is the chair of committee. And then you shall be controlling who has the floor or who can talk at a time. So in other words, so if the HR head is the one who leads or the chair of the committee, so you need to act as the presider, no, or the facilitator. So you will be the one to decide who will talk first and next, no. And then you need to read and explain also the incident report. So the specific provisions that were violated. So normally you can see that in the notice to explain, no. So you just read all those written in the notice to explain, and impact of the incident to people and property, safety and security, the company image and brand reputation, or whatever is applicable. And then you need also to present documentary and testimonial evidences. So based on those incident reports, so in addition to that, if you have witnesses invited, then you let those witnesses talk also, no? To really lay down what took place. Okay? And then give ample time for the employee being investigated to answer the allegations against him or her. So to bring a representative of their choice to present his her own evidences. Okay? So if the employee the being investigated brings with him his lawyer or his legal counsel, he can actually do that, no? Because that's part of his right. And then give opportunity for other attendees to ask question or clarify. And then for any item which may have been forgotten, the person taking the minutes should read the prior discussion. So before dismissing the meeting, advise the attendees if there is a need for another meeting. If none, advise them how long will it take you to submit the resolution of the case. So that's how you do the administrative hearing or conference. Okay? So again, you only need to do the administrative hearing if there's no admission of guilt, no? uh, by the employee with his explanation letter in response to the notice to explain. Okay. So after the meeting, you have a week to complete the following. So you need to evaluate the incidents, or prepare a case report for approval of management, then issue a notice of decision memo. So in evaluating the incident, of course, you need to consider all those submitted evidences, no, the documentary evidences, the minutes of the meeting, what information has been given, no, and all those things. And then you need to prepare a case report for approval of management. Okay, so that's a summary of the investigation you've done, no? Which includes the hearing. And lastly, upon making the decision, you need to issue a notice, which is the second written notice, no? Which is the notice of decision. So it could be termination or what, no? So it would depend on the decision of the case. Okay. Now, another part of investigation is you may put or you may place the employee under preventive suspension. No? So the employer may place the worker concerned under preventive suspension if his continued employment poses a serious and imminent threat to the life or property of the employer or his co-workers. So you can find the preventive suspension under the implementing rules and regulation of the Labor Code, Book 5, Rule 13, as amended by Department Order Number 9 on June 21, 1997. Okay? So for the preventive suspension, the maximum there is 30 calendar days. Otherwise, it will constitute constructive dismissal. So, in other words, preventive suspension is only limited, no? And that's for only 30 calendar days. Now, what will happen if the investigation is not yet done, no, or finished within 30 days? So, as an employer, you have two choices. Number one is you must reinstate the employee, meaning you must advise the employee to go back to work even the investigation is not yet done, no? Or there's still no decisions made. Secondly, you can continue the preventive suspension, but you need to pay the employee already of his salary or his daily pay, no? So you may ask the employee to go on suspension, but depending on how many days are extended, the employee will be paid on that number of days, no? Uh, for more than 30 days if it will, yeah, exceed 30 days. So in other words, you're going to pay the employee if you don't want to reinstate or let the employee go back to work. So you have no choice but to pay the employee of his salary. That's your remedy as the employer, or your option, no? In cases of uh, preventive suspension, if it will go beyond 30 days. And for the burden of proof, in other words, who has the party or the side to prove, no? So it is the duty of providing a disputed assertion of charge. So the burden of proving the validity of dismissal rests upon the employer. So, but the burden of proving the fact of dismissal rests upon the employee. So employees who claim that they were dismissed have the burden of proving such allegation. So in other words, for the employer, the burden there, on the case of the employer, is to prove that the dismissal is valid. Okay? And how are you going to prove that the dismissal is valid? Number one is the cause must fall under the substantive due process, and of course you follow the procedural due process, and you have all the evidence proof uh, that to prove the validity of such dismissal, no? And then for the employee side, the burden there is for the employee to prove the fact of dismissal, uh, is not ano no but the burden of proving the fact of dismissal rests upon the employee. So in other words, the employee need to also prove no that the fact of dismissal is I mean is illegal or not valid. Okay, so the employee who claimed that they were dismissed have the burden of proving such allegations. So they need to prove that the allegations are not true. Okay, on the part of the employee. So the employee should have also evidences to prove, no, for in his favor. So the degree of proof, it is not enough. It is enough that there be substantial evidence showing some basis, therefore, or that the employer has reasonable grounds to believe, if not entertain the moral conviction that the employee concerned is responsible for the misconduct. So the degree of proof is only substantial evidence. Unlike criminal offenses, uh, the proof is beyond reasonable doubt, no? But in cases of labor disputes, only substantial evidence is necessary. Okay, so that ends the procedural due process. So again, as HR, you must always remember that before you can terminate the employment of an employee, you need to follow or certain considerations, no? Especially number one, it should be be you should comply the substantive due process, whether it's a valid cause or authorized cause, and then of course the requirements there. And then secondly is the procedural due process, which includes first notice, written notice stating the violations, and of course if there's no admittance, then a hearing must be conducted, and after the hearing and all those evidences being assessed or evaluated, then a written notice of decision whether to terminate the employee, and then those circumstances why you reach the decisions of termination. So those are the requirements that you need to consider in terminating an employee. Okay, so that ends our discussion for today. So I will be giving you a case study in relation to this discussion, and of course that will be graded. So due date will be provided in the our platform. No? It will be yeah, it will be stated there. Okay, so again, that ends our topic, our discussion for today. So if you have questions, please feel free to message me or send your question to our class BDL. But if you want an urgent answer on that, so please directly message me, no, for your question. Okay, so again, thank you and enjoy the rest of the day.